What happens when a government investigates its enemies? Without lawful authority? That is not a hypothetical question. It is happening now. This week, a federal judge ruled that a prosecutor investigating Letitia James was never legally allowed to hold that power. Not yesterday, not today, not at all. This was not a paperwork error. It was a systemic failure. Because when the executive branch bypasses Congress and uses that shortcut to pursue a political rival, the issue is no longer Donald Trump or Letitia James. The issue is the rule of law itself. America's democracy does not usually break with tanks in the streets. It erodes quietly through legal loopholes, through acting officials, through power that assumes legitimacy it never earned. If you believe democratic guardrails protect themselves, this case proves otherwise. Pay close attention. Because once lawful authority becomes optional, no institution is truly safe. In the next part, I'll explain what this case is really about and why it should worry far more people than it currently does. To understand why this ruling matters, we need to be precise about what is actually being challenged here. This is not a debate about guilt or innocence, not about Donald Trump's business practices, and not about Letitia James as a political figure. At the center of this case is a simpler, more dangerous question. Who has the legal authority to wield the power of criminal investigation? In the American system, that power is not symbolic. It can destroy reputations, drain resources, and alter political outcomes. That is why Congress set clear rules. A U.S. attorney must be confirmed by the Senate, or, if that process fails, appointed by the court. Those rules are not technicalities. They are safeguards. But in this case, the Trump administration attempted something else. It installed a prosecutor, labeled him acting, and allowed him to pursue investigations into a political adversary without lawful authority. The judge's ruling forces us to confront a reality many prefer to avoid. When legal shortcuts become normalized, the system itself becomes the target. And that brings us to how this situation began in the first place. To see how we arrived at this moment, we need to step back from personalities and look at the system. For decades, the appointment of U.S. attorneys followed a predictable rhythm. A president nominates, the Senate confirms. Legitimacy is established. When that process stalls, the law provides a backup. Temporary appointments, strict time limits, and ultimately judicial oversight. These rules were designed for one reason: to prevent raw political power from turning prosecutors into weapons. But over time, that restraint weakened. Acting officials became more common. Temporary roles became extended, and ambiguity replaced clarity. In this case, that ambiguity was pushed even further. An interim appointment expired. The court declined to step in, and the executive branch found another path, relabeling authority rather than relinquishing it. This was not accidental. It was procedural, calculated, and legally aggressive. What began as a workaround slowly transformed into a governing strategy, and once that line is crossed, the system stops protecting itself. Which is why the next moment, the first real flashpoint, was almost inevitable. The first real crisis arrived quietly, not with an arrest, not with charges, but with subpoenas. In August, the acting U.S. attorney signed grand jury subpoenas aimed directly at the New York Attorney General's office. They demanded records, internal materials, information tied to investigations that Donald Trump had openly opposed. On the surface, this looked procedural, routine, almost boring. But beneath it was something far more serious. A federal prosecutor whose authority was already legally questionable was using the criminal justice system to scrutinize the actions of a political adversary. That is the moment when abstraction becomes danger. because subpoenas are not neutral. They carry the force of the state. They compel compliance and they signal intent. If you're watching this closely, this is where alarm bells should start ringing. Power was being exercised first. Legitimacy was being argued later. And history tells us this order matters. The judge's ruling would later erase these subpoenas, declare them void. But the damage was already done, because once the machinery of investigation is set in motion, the system itself begins to tilt. And that brings us to the deeper mechanism at work, the one most people miss entirely. What made this situation especially dangerous was not a single decision, but a hidden mechanism built into the system. The title acting U.S. attorney sounds temporary, harmless, administrative, but in practice, it carries enormous power. An acting prosecutor can convene grand juries, issue subpoenas, open criminal investigations, all without ever facing a Senate confirmation hearing. That hearing is not ceremonial. It is where legitimacy is tested, where conflicts are exposed, where power is slowed down on purpose. By relying on unconfirmed prosecutors, the executive branch bypasses that friction entirely. Speed replaces scrutiny. Control replaces consent. In this case, when the 120-day interim term expired and the court declined to appoint a successor, the system should have paused. Instead, it adapted, titles were reshuffled, authority was reasserted under a different name. Legally creative, politically convenient, and deeply corrosive. Because once power learns it can rename itself to survive, oversight becomes optional. This is not about one prosecutor. It is about a model where legality is stretched just far enough to achieve political ends. And once that model exists, it rarely stays contained, which is why the next crisis would not be quieter. It would be sharper. The second crisis did not arrive with subpoenas. It arrived with a ruling. A federal judge stated plainly and without ambiguity that the prosecutor exercising this power was never lawfully authorized to do so. Not partially, not temporarily. At all, those words matter, because the judge did not simply criticize a process, she invalidated it. Every action taken under that authority, she wrote, was void or voidable, past, present, future. And then came the most striking line: when the executive branch bypasses restraints set by Congress and uses that power to target political adversaries, it acts without lawful authority. This was no longer an internal disagreement. It was a constitutional rebuke, and it was not isolated. Courts across the country, New Jersey, Nevada, California, Virginia, had already issued similar decisions. Different districts, same pattern. Unconfirmed prosecutors, expanded authority, judicial pushback. What we are witnessing is not chaos. It is a system in collision with itself. And when institutions collide, ordinary people rarely feel the impact immediately. But that is about to change. Because the next question is not legal, it is personal. Now, let me bring this back to you. Because this story is not really about prosecutors or judges or political elites, it is about what happens when power stops playing by the rules. Imagine being investigated by someone who does not legally have the authority to investigate you. Imagine hiring lawyers, spending years defending yourself, only to later learn the process itself was invalid. Even if you are never charged, the damage is real. Time is lost. Money is drained. Trust is broken. And here is the uncomfortable truth. If this can happen to a sitting state attorney general, it can happen to anyone. The law is supposed to protect you from arbitrary power, not expose you to it. When legal authority becomes flexible, justice becomes unpredictable. And unpredictability is the enemy of freedom. This is why court rulings like this matter, even when they feel distant. If you believe the rule of law should apply evenly, not selectively, this is your fight too. Remember this moment, share it, talk about it, because what seems abstract today becomes personal faster than we expect. And the consequences do not stop at national borders. What happens inside the American legal system never stays inside America. For decades, the United States has positioned itself as a model of constitutional restraint. Independent courts, clear limits on executive power, rules that apply even when politics are messy. That credibility matters because allies watch closely, and so do rivals. When courts repeatedly rule that prosecutors were unlawfully empowered, the signal travels fast, not just to Washington, but to Beijing, Moscow, and capitals across the developing world. Authoritarian leaders notice patterns. They do not need America to fail completely. They only need it to look inconsistent. Every time legal authority appears flexible, it weakens America's ability to argue that law, not power, should govern. This is how norms erode globally, not through invasion, but through example. And the damage compounds. International cooperation depends on trust. Extraditions, sanctions, joint investigations. When legitimacy is questioned at home, credibility erodes abroad. The irony is striking. The very tools meant to project strength can end up undermining it, which leaves us with the hardest question of all. What happens next? Because the future of this system is not fixed. It branches. From here, the system moves in one of three directions. The first is the optimistic path. Courts continue to enforce boundaries. Congress reasserts its authority, and future administrations of any party learn that bypassing confirmation has real consequences. In this scenario, the damage is contained. The system bends, but it does not break. The second path is more likely and more dangerous. Legal gray zones become normalized. Acting officials remain a convenient tool. Each administration pushes a little further than the last. Nothing collapses dramatically. Instead, legitimacy thins, trust fades, and power quietly concentrates. Democracies rarely fall all at once. They erode through repetition. The third path is the darkest. Judicial pushback is ignored. Court rulings are treated as obstacles, not limits, and legal authority becomes openly partisan. In that world, investigations are expected to serve politics, not justice. Once that line is crossed, restoring credibility is extraordinarily difficult. The lesson here is uncomfortable but necessary. Systems do not survive on good intentions. They survive on enforcement, and enforcement only works when people still believe the rules matter. Which brings us to the final question. What do we do with this moment? Moments like this rarely announce themselves as historic. They arrive as court filings, technical rulings, procedural disputes most people never read, and that is exactly why they matter. Because the health of a democracy is not measured only at the ballot box. It is measured in whether power accepts limits when doing so is inconvenient. This case is not about whether you support Donald Trump or Letitia James or any political party. It is about whether the law restrains power or whether power reshapes the law to suit itself. History is clear on one point. Once legal authority becomes conditional, freedom becomes fragile. The guardrails do not disappear overnight. They weaken, they bend, and then one day we notice they are gone. The courts acted here for now, but courts are not self-executing. They rely on public attention, public pressure, and public memory. If you care about the future of democratic systems, don't look away from moments like this. Share this conversation, question authority, demand legitimacy, because the most dangerous political illusion is believing the system will protect itself. It never has.